I would like to go over a few housekeeping items so that we know specifically for CLE and presentation materials where those will be housed. If you have questions, you can enter the questions via the question and answer widget on the left-hand side of your screen. We will address all questions at the end of the program, time permitting, and if we are unable to get to them, we will address them after the program via email. There will be a recorded version of this presentation provided to all who RSVP'd a few days after the presentation. We will also be providing a copy of the presentation in PDF form for those who are interested. For those of you who would like CLE credit, we ask that you fill in a questionnaire towards the end of the presentation requesting a specific CLE code, which I will read off. Once the presentation has been complete, those CLE credits will be submitted for approval and will be emailed to you in approximately 8 weeks. Those seeking CLE credit in Kansas, New York, or New Jersey are required to fill out an attorney affirmation form, which you should be able to find on the lower left-hand corner of your screen. And with that, I will hand it off to Sarah.
Thank you, Jason. Good morning and good afternoon, everyone. My name is Sarah Slack, and I'm a partner in Foley's Environmental Practice Group. I'm going to begin this morning or afternoon with our presentation. I'm going to start by going with a quick overview of what we're going to cover, and then I'll provide some background information on how RCRA basically works before turning it over to Laura Whiting and Pete Smasi to go over some additional information about the rule specifically that we're here to talk about today, as well as kind of the status of that, considerations with respect to state and interim compliance, and then how best to prepare for the changes that we see coming. So first, really briefly, we are here today to talk about EPA's new hazardous waste pharmaceutical rule. So prior to the rule being finalized, excuse me, hazardous pharmaceutical wastes were basically subject just generally to requirements under RCRA. So to the extent that a hazardous pharmaceutical waste was designated as hazardous, it just had to be managed as a RCRA hazardous waste. On February 22nd, 2019, EPA published its revised version of how these hazardous waste pharmaceuticals are going to be handled in what it anticipates is supposed to be a relaxed version of the standard that is designed to make it easier and more user-friendly for folks to use. And I know that Laura and Pete are going to go into a lot more detail on that. But first, let me just give a little bit of background. So RCRA is the federal cradle-to-grave regulation of all hazardous waste. So basically, from a time that a hazardous waste is generated, through its transport, through any treatment, and then through its ultimate disposal, RCRA regulations are in place that address how those materials are to be managed, handled, what record keeping is required and associated with that, and all of those types of details. For the most part, as with many EPA programs, EPA has delegated its authority under RCRA to the states, and through that process, each state then promulgates and implements regulations that are at least as stringent as the federal rules in the 40 CFR sections referenced here. Then each state and EPA have the ability to enforce those state regulations. Exceptions to this are Iowa and Alaska, which are both direct implement programs. They follow the federal program directly. Under RCRA, there are 3 basic types of entities that are regulated. The first is waste generators. The second is waste transporters. And then the third is going to be facilities that treat, store, or dispose of hazardous waste. And those types of facilities are generally referred to as TSDFs. At the time that a generator generates the hazardous waste is what's key in here is in determining whether or not that waste stream is hazardous. and it is on the generator to make that determination and ensure that the hazardous waste streams are disposed of at authorized facilities. As I indicated before, this includes making sure that proper manifesting is done, that detailed records are done, any waste profiles are maintained, and waste reports are filed, etc. So how does RCRA work? Again, today we're going to focus mostly on generators, and so there are 3 basic types of generators under RCRA. The first is going to be large quantity generators. Those are generators who generate more than 1,000 kilograms per month or more than 1 kilogram per month of acute hazardous waste. And there are a number of, the regulations are most stringent with respect to large quantity generators and what types of management requirements they have. The second group is small quantity generators. Those are the ones that generate less than 100 or 1,000 kilograms, between 100 and 1,000 kilograms per month of waste. And then the very small quantity generators generate less than 100, but more than a kilogram of acute hazardous waste per month. Again, TSDFs are going to be the facilities that actually receive and handle the waste. Those are going to be subject to the most stringent of permitting requirements, including operational requirements, record keeping, financial assurance, and then closure requirements too. So again, the kind of threshold question under RCRA is whether or not a waste is a hazardous waste. There are 2 questions. The first is it solid waste? And a solid waste doesn't actually have to be solid. Oftentimes solid wastes are actually liquid or in gaseous form. And basically it's any type of waste that has served its purpose and is not intended for any future use. So the question is it useless? And if so, are you ready to discard it? If the answer to those questions is yes, then it's waste. If on the other hand, it could legitimately be reused or reclaimed, it may not be waste. It may be eligible to certain exemptions or exceptions to the rule. And again, this is kind of one of those threshold questions. The second element of the question is whether or not it's a hazardous solid waste that falls into one of 2 categories. So there are 2 ways that a waste can be considered hazardous. The first is it can be a specifically listed hazardous waste. And so those wastes are wastes that EPA has specifically identified and which have a letter designation and then a number designation as being a listed waste that is hazardous for purposes of RCRA. The other way that material can be hazardous is if it's characteristically hazardous. So again, here EPA has identified that certain types of characteristics make a waste hazardous. Those are substances that are going to be ignitable, corrosive, reactive, or toxic. So just for purposes of this program, we thought it would be helpful to give some examples of relevant listed wastes. So for purposes of healthcare facilities and those types of users in particular, we note that P and U waste codes are likely the most relevant, especially under the rule we're discussing today. So P and U waste codes refer to unused commercial chemicals, and some examples of P codes that are listed include warfarin, nicotine, arsenic, trioxide, and other packaging associated with that. We note that handling just 1 kilogram per month of acute P-listed waste can trigger extensive large quantity generator waste management requirements. So again, here that can be a significant factor in determining a generator's status under RCRA. U codes are for discarded products or mixtures that have less than 10% U materials. And some examples of those, again, that are relevant for our conversation today are cepastat lozenges, chloroseptic spray, Respirine, and selenium sulfide. F codes refer to wastes that are generated in common manufacturing processes, and for the most part, those they may not necessarily be relevant. However, there are a few that we know that may be relevant to the healthcare industry, including solvent-type waste that are generated in diagnostic labs. So F waste, some examples of that is spent non-halogenated solvents like xylene and acetone, as well as ethyl acetate and butyl alcohol, cyclohexanone, and methanol. and then also spent non-halogenated solvents like toluene, isobutanol, and benzene. We didn't list any examples here of K-waste because those are going to be industry specific and aren't really going to be relevant here today. Oh. Apologies. Having an issue. There we go. So again, just to summarize, is it a hazardous waste? The initial question is going to be, are you, the healthcare facility or the reverse distributor, again in the context of the current rule, ready to discard it? Can it be reused or reclaimed in an appropriate manner? If yes, it may not be waste or hazardous waste. If no, then it's going to be considered waste. Is it listed under EPA state or hazardous waste code, or does it exhibit a characteristic of a hazardous waste? If yes to either of those last two questions, then it's going to be considered a hazardous waste. Now, again, the key point is that it becomes hazardous waste when the decision is made to discard it. So that's going to be made at the point of generation, which is going to be relevant for some of our discussions here today, and I just wanted to highlight it. So then, with that, I think I'm going to turn it over to Laura Whiting, and she'll continue to walk us through with more specific details on the Pharma rule. Laura?
Thank you, Sarah. Can everyone hear me? Appreciate that introduction. And yeah, my name is Laura Whiting, and I'm a partner in the Dallas office. And now that we have a basic understanding of RCRA, we want to focus now on the pharmaceutical rule in the broader RCRA context. And let me first start by telling you what the pharmaceutical rule is not. It's not a rule addressing medical waste. Medical waste continues to be addressed separately, regulated by the states, including as dual waste, which is hazardous waste subject to RCRA, as well as state medical waste requirements. This would be the category of discarded blood, sharps, human tissue, bandages, and the like. Rather, the pharmaceutical rule addresses pharmaceuticals, pills, liquids, creams, ointments, their containers, and materials such as that. This rule applies to a broad range of healthcare facilities, we call them HCFs for short, and reverse distributors, or RDs. We'll get into the definition later, but I want to show you an overview of the types of facilities that are covered. EPA included this list in the preamble to the final rule. Very broad, as you can see. It covers drugstores, hospitals, physicians' offices, nursing care facilities, certain types of long-term care facilities, and reverse distributors, which is sort of a different animal from these other types of facilities. So here we have on slide 11, I want to provide a general overview of the way we view what EPA is trying to achieve with this Pharma rule. EPA sets up a prescription pharmaceutical waste management system in very broad terms. In step 1, EPA codifies Minnesota's position that all prescription pharmaceuticals become waste when the decision is made to dispose or send the pharmaceutical, the prescription, to a reverse distributor. That then first triggers the waste management standards and requirements at the healthcare facility that is making that decision. And then in step 2, EPA creates streamlined handling, disposal, and reporting requirements for all hazardous waste pharmaceuticals that would otherwise be subject to the full suite of RCRA requirements. These requirements, those standards, are in the Subpart P standard, we call it. Also, EPA has a non-prescription off-ramp from RCRA and Subpart P. In this step 3, essentially, EPA codifies prior guidance and allows healthcare facilities to send reusable, non-prescription, non-hazardous pharmaceuticals to reverse logistics centers as products and not as waste. Therefore, the regulations don't apply because it's not waste. But this is allowable only if there is a legitimate expectation for reuse, such as donation or reclamation. So think over-the-counter drugs, homeopathic drugs, and dietary supplements. Major changes that we want to focus on first before getting into the details include these. Mainly that EPA is officially banning the flushing and sewering of all pharmaceutical waste in all states effective August 21 of this year. EPA is also amending the nicotine listing, the hazardous waste listing P75, and no longer considers FDA-approved over-the-counter nicotine replacement therapies to be hazardous waste. So the used and unused nicotine gums, patches, and lozenges can now be disposed with ordinary trash. However, e-cigarettes, e-liquids, and the like are still regulated as hazardous waste pharmaceuticals under this rule and the broader RCRA program. The pharmaceutical rule, as we said, takes effect on August 21, takes immediate effect in Iowa and Alaska on the 21st. In all other states, the Subpart P requirements won't take effect until after each state adopts its rules implementing the federal rule. So you will see that we may very well have a compliance gap in many states where the federal rule becomes effective and interpretations under the federal rule become effective, but the state rules have not caught up yet. Pete will talk more about that later this morning. I want to talk a bit about the history of RCRA and its relationship to pharmaceuticals and the healthcare industry. As noted before, certain pharmaceuticals such as warfarin and nicotine are considered acute hazardous waste when the decision is made to discard them. So generating a minimum of 1 kilogram per month of such waste triggers the onerous large quantity generator requirements under RCRA. So in 1981, realizing that this was indeed a tricky situation, EPA issued guidance to a particular pharmaceutical manufacturer that generally applied across the industry over time. EPA said that for product returns, that is when a healthcare facility will ship unused pharmaceuticals back to the manufacturer for manufacturer's credit, EPA determined that when those returns are sent to the manufacturer or also to a reverse distributor, the point of generation, the point at which that substance becomes a waste, is actually at the manufacturer's plant or at the reverse distributor's facility. EPA deemed that to be the point at which the waste determination was made rather than at the healthcare facility. That meant that the healthcare facilities could ship that material back to the manufacturer or reverse distributor as a product. And as a product, the RCRA waste requirements did not apply and have not, over the past 2 or 3 decades, generally not applied. And so you also saw states like Connecticut, Washington, and Minnesota adopting state policies, variations on that general theme for pharmaceuticals under RCRA. EPA, and let me go to the next slide. Here we go. So EPA and industry and the states recognized that this was an imperfect system. We were essentially trying to put the square pharmaceutical industry into the round hole of the RCRA system. And folks continued to ask whether it made sense for healthcare facilities and reverse distributors to be managed as large quantity generators of hazardous waste when the volumes for acute hazardous waste were so small. Folks also continued to ask how a healthcare facility should manage non-prescription hazardous medications when shipped to reverse distributors. Was it really appropriate to consider the discard point all the way back up the chain? Folks continued to ask how best a healthcare facility should manage used containers with residual medication in them. The traditional RCRA regulatory rule, called the RCRA empty rule for containers, did not apply very readily to the healthcare context. Folks also asked whether chemotherapy agents should be regulated as toxic under RCRA. These, on the next slide, These questions, serious questions, have been evolving of late concerning contamination in wastewater treatment plant effluent due to the sewering of unused pharmaceuticals, whether that's household or healthcare facilities. And speaking of household, the long-term care facilities has previously been exempt by interpretation under the household waste exemption from RCRA. But given that some of these facilities can generate a good quantity of hazardous and non-hazardous pharmaceuticals, there have been lingering questions as to whether or not that was appropriate to apply that exemption. Finally, there's a complex overlap between EPA and Drug Enforcement Agency authorities. Certain narcotics are DEA-scheduled medications or drugs that must be disposed of pursuant to regulations under the DEA to ensure proper destruction and to avoid diversion of the drugs. And just covered that. And I apologize. There we go. The slide is flipped. So I want to talk a bit about the rulemaking process when EPA got serious about trying to make changes. In 2008, EPA proposed to include hazardous waste pharmaceuticals under the Universal Waste Program, which, as you probably know, applies to things like fluorescent lights and batteries. However, there were lingering concerns regarding diversion of DEA compounds that could happen in the Universal Waste regime. So this rule was never finalized by EPA, but that type of program was adopted in Florida and Michigan. There were continuing efforts by state and federal industry partnerships to provide guidance. For example, the blueprint that is currently still on EPA's website as an appropriate method for managing pharmaceutical waste. I apologize, this is going backwards. And in 2010 through 2015, EPA continued to further evaluate the unsafe management practices, including a rather scathing Inspector General report. Texas did its own study on methods for disposing of unused pharmaceuticals and identified problems, including problems in wastewater effluent. In 2016, EPA released what it called its retail strategy, where it committed to developing a policy for reverse distribution, the entire retail sector, and to completing the pharmaceutical rule. That brings us to 2015, where EPA proposed the current rule that we're now looking at as a final rule. There were over 200 public comments filed on the rule, primarily focusing on issues such as the very broad definition of healthcare facility, significantly broadening the scope of management requirements, the detailed record-keeping requirements, the lack of clarity on what constitutes creditable pharmaceuticals, and concerns about how to manage small-scale pharmacies. So let's talk about a couple of the key definitions in the final rule that was just released. Of course, the main definition would be healthcare facility, which means any person that provides preventative, diagnostic, therapeutic, rehabilitative, maintenance or palliative care, counseling, service, assessment, etc. I won't read the whole thing to you, but it is a very broad definition. This is the regulatory definition, and it also covers animal healthcare. Healthcare facility also includes facilities that distribute, sell, or dispense prescription or over-the-counter pharmaceuticals, dietary supplements, and homeopathic drugs. It includes hospitals, pharmacies, clinics, physician and dental offices, long-term care facilities, and this is new, surgical centers, wholesale distributors, and veterinary clinics, but not manufacturers or reverse distributors under this definition. It includes veterinary clinics, but not ranchers or farmers. The official definition of long-term care facility is a licensed entity that helps with daily activities, including administering pharmaceuticals. For example, skilled nursing and hospice, but not group homes or assisted living. And a key definition to the way the whole rule works is this one: potentially creditable hazardous waste pharmaceutical. It's a mouthful, but what it means is hazardous prescription pharmaceutical waste with a potential for receiving manufacturer's credit. It must be in original packaging, undispensed, and unexpired, or within less than 1 year past its expiration date. If a healthcare facility has on hand potentially creditable hazardous waste pharmaceutical, the facility may ship these wastes directly to a reverse distributor for credit, and from the reverse distributor for ultimate disposal, or the facility may directly ship the unused waste to a licensed treatment storage disposal facility for disposal. The corollary definition would be a non-creditable hazardous waste pharmaceutical, which is either a prescription hazardous pharmaceutical with no reasonable expectation for manufacturer's credit, or a non-prescription hazardous pharmaceutical with no reasonable expectation for reuse or reclamation. So this would include the universe of investigational drugs, free samples, residues, contaminated personal protective equipment, floor sweepings, spill cleanup, and the like. The point here, non-creditable hazardous waste, it's obviously a waste. And since it's obviously a waste at the healthcare facility, it cannot be reused, the healthcare facility is now deemed the waste generator and must ship directly to a licensed treatment, storage, and disposal facility for disposal. The healthcare facility is prohibited under the regulations expressly from sending that hazardous waste pharmaceutical to a reverse distributor. It must go directly to disposal. And for clarification, a pharmaceutical reverse distributor means any person that receives and accumulates potentially creditable prescription waste pharmaceuticals for the purpose of facilitating or verifying manufacturer's credit. That's hazardous or non-hazardous. And a reverse distributor may be any forward distributor, any third-party logistics provider, any drug manufacturer that accepts these hazardous meds for processing credits. And keep in mind, even in the preamble, EPA states that it assumes that almost all prescription medication ultimately will be disposed of rather than reused or reclaimed. And we need to compare reverse distributors to what EPA calls reverse logistics. A healthcare facility may ship unused, non-prescription, non-hazardous waste pharmaceuticals as product to a reverse logistics center if there is a reasonable expectation of reuse. These reverse logistics centers are not covered by Subpart P. Now diving kind of into the rule, Subpart P itself, for healthcare facilities and their generator requirements, it's sort of step one in managing these materials at the healthcare facility, the hospital, or what have you. The facility must categorize all of its unused pharmaceuticals, whether they're creditable or not from the manufacturer, and whether there's a reasonable possibility that the medication can be reused or not. The healthcare facility must determine whether unused med, if not creditable or reusable, qualifies as a RCRA-listed or characteristic hazardous waste. This is step one in waste generation. Is it a waste, and is it hazardous? The healthcare facility need not anymore count monthly quantity of hazardous medications towards the facility's RCRA generator status if the medications are managed under Subpart P. Remember, a healthcare facility may continue to generate other types of hazardous waste. Those requirements don't change for the healthcare facility, and these medications managed under Subpart P don't count to that other tally of quantity of hazardous waste for regulatory purposes. Also, hazardous waste pharmaceuticals monthly quantities do not trigger generator categories. That's small quantity and large quantity, also known as very small quantities today. And in the management standards that apply to the healthcare facilities, we'll note that training for all personnel is required that manage non-creditable hazardous waste medications for handling and emergency procedures. Keep in mind, these are less stringent than the requirements that apply to large quantity generators. It is considered basic training for nurses and managers handling these types of materials. There are, as with RCRA, container labeling requirements, but they're more simplified, and all that's required is a container to indicate hazardous waste pharmaceuticals. There continues to be an accumulation limit, but it's relaxed, and the facility must track by inventory, container labeling, or record an accumulation area. So there's flexibility there for tracking and recording and accumulating. In addition, there continue to be shipping requirements, but they're relaxed. The shipper of hazardous waste must use a manifest, but they do not have to put the individual waste codes anymore on each material. They simply indicate farms in the waste code instead of the EPA waste code. And there continue to be packing, labeling, and marking requirements per the Department of Transportation requirements. And with that, I'm going to wrap up on direct healthcare facility requirements. Thomasy is going to talk about the requirements that apply to reverse distributors and further where we go from here in managing the transition to Subpart P nationally and in the various states. So take it away, Pete. Thank you.
Thank you, Laura. I'm Pete Thomasy. I am of counsel with Foley in our Milwaukee office, and I will, as Laura said, I'll sort of finish up hitting some of the key points set forth in the rule related to reverse distributors, record keeping and notification, make some notes on changes to current practices, and then talk about state implementation and interim compliance and how best that facilities nationwide can prepare. And Sarah and Laura will actually chime in on 2 separate states. So turning to the reverse distributor requirements, and I don't know, Laura identified the difference between reverse logistics and reverse distributors. And I don't know how many reverse distributors are on the webinar today, but essentially reverse distributors receive potentially under the rule. In practice, reverse distributors provide a very valuable service by receiving, warehousing, and sorting creditable pharmaceuticals and assigning credit to companies and then determining what to do with them. Under the rule, reverse distributors receive potentially creditable prescription pharmaceuticals from pharmacies or any other healthcare facility that Laura identified under the definition. All of those facilities have to maintain an inventory of the potentially creditable hazardous waste pharmaceuticals that are on site. That sounds problematic, but most reverse distributors have an automated system where every package that comes into the facility is scanned, and that's functionally required to comply with the Drug Supply Chain Security Act. So that functionally is already done. In addition, reverse distributors have to evaluate the creditability of those received potentially creditable pharmaceuticals within 30 calendar days of receipt. After which point they are deemed to be an evaluated hazardous waste, or they may be shipped to a different reverse distributor for further evaluation. reverse distributors, under the proposed rule, reverse distributors had 21 days to evaluate. Under the final rule, that's been stretched to 30. And under the proposed rule, reverse distributors were treated like any other large quantity generator and had to ship any hazardous waste pharmaceuticals that have been evaluated off-site after 90 days. Final rule sets that the accumulation time as 180 days, and also separately addresses a point that was raised in comments by reverse distributors on a proposed rule that an expired pharmaceutical can still be held on site for up to 180 days. The rule has some of the requirements that anyone familiar with large quantity generator regulations will be familiar with. There has to be a designated accumulation area for hazardous waste pharmaceutical. It needs to be inspected on a weekly basis. Waste pharmaceuticals have to be stored in compatible packaging, which usually is already done, meaning you can't store a hazardous waste pharmaceutical in something that will react with the chemical. And finally, there needs to be training, a training program in place for individuals at the facility. In addition, in a nod to the DEA consideration and scheduled drugs, there needs to be a facility security plan to avoid diversion, primarily of scheduled substances, painkillers, for example. These facilities need contingency plans, emergency procedures, and they also have to address specific record-keeping requirements. It's the responsibility of the reverse distributor to maintain the inventory we mentioned, as well as maintain documentation of delivery of each shipment from a healthcare facility, along with the US DOT shipping papers for a period of 3 years. So EPA, not unlike the additional obligations that are put on treatment, storage, disposal facilities for hazardous waste, has put on the reverse distributors a lot of the compliance burden for record keeping, as opposed to requiring healthcare facilities to do that as well. What do reverse distributors have to do? They all have to notify US EPA before the applicable deadline in August that they are operating under Subpart P. And I should note, I've covered a few of these points under the previous slide, but if there is EPA has a 3-year window for retaining records. If there's an enforcement inspection, that window is automatically extended under the rule. And potentially credible hazardous waste medications are not part of what's known as a biennial report for a large quantity generator. So somewhat different requirements than as compared to a large quantity generator rule. Key point, there is a ban on disposal of drugs by sewering, which was something that many people were taught, and actually my spouse is in the healthcare field and was taught to flush scheduled substances to get rid of them. That practice has been banned by the rule and goes into effect nationwide in August because of the specific authority under RCRA under which it's implemented. An additional important change to note, so you can't sewer pharmaceuticals going forward, and in the longer term, if entities continue to do that, there may be, you could see an enforcement initiative if EPA or Treatment Works find that they are finding pharmaceuticals in their waste stream. There is a capability to trace them upstream. In addition, one of the key points that is actually a benefit of this rule is a change in the process by which RCRA empty is determined for pharmaceutical containers. For anything that is a pharmaceutical container, unlike other acute hazardous waste, to be determined to be empty, it doesn't have to be triple rinsed. So these are things like the examples set forth in the slide of blister packs and used devices, dispensing bottles up to a volume of 1 liter or 10,000 pills. Dispensed syringes do not need to be opened and triple rinsed out. all other containers that held listed or characteristic pharmaceuticals are not subject to this exemption and still are subject to the standard regulation. An additional sort of change in practice, there's overlapping DEA and EPA regulation for a small set of pharmaceutical compounds, and for DEA-controlled substances, as well as controlled substances that have been mixed with household waste under take-back programs, those are subject to exemption under RCRA so long as they are disposed of consistent with DEA regulations, meaning they're incinerated, and that incineration is appropriately tracked pursuant to DEA regulations. Turning to state implementation. For states other than Iowa and Alaska, states have something called delegated RCRA authority. That means other than Iowa and Alaska, the subpart 40 CFR Part 266 subpart P, which contains the majority of the final rulemaking other than the sewering ban, doesn't go into effect immediately. It will go into effect only when the affected states draft and adopt their own implementing regulations. EPA notes in the preamble to the rule that the agency's position is, on balance, subpart P's requirements are more stringent than what RCRA currently requires, and therefore EPA believes all states are required to implement subpart P. However, and the preamble notes this in a number of places, if specific elements of existing state programs, and Sarah will talk a little bit about California, for example, but if states have more stringent requirements, then they are not required to adopt provisions that EPA is proposing under subpart P that are less stringent than their existing state program. So we may end up with something of a patchwork on a state-by-state basis with respect to subpart P. Same with the nicotine redesignation. States are not required to adopt that change because it theoretically is a loosening of the federal RCRA requirements. So turning to the point that I think is of greatest concern for some of the entities that we have discussed this rulemaking with is sort of what do we do in the interim period between August 22nd of this year, when EPA's rule enters into effect, and the point at which in weeks or months, or in some cases years, when states actually put in place a rulemaking that adopts all the federal rules. The key change is the one that is noted in slide 32, which is that EPA stated in the preamble that it had revised its interpretation, previous interpretation for the point of generation of waste. Previously, EPA and most states had taken the position, there was some inconsistency, but that reverse distributors were really the entities that were making the determination as to when a pharmaceutical is going to be disposed of. And really, because of the complexities of some of the contracting between different reverse distributors and pharmacies, in some cases that was a very easy case to make. For others, it was a little more complicated. The problem with that change, but subpart P protections only apply after states adopt the regulation. So effectively, in every state in August, if states choose to and follow US EPA's policy regarding when a product becomes hazardous waste, states will be subject to determining that pharmacies are the point of generation for pharmaceuticals that are being sent back to reverse distributors. But the streamlining of the rule won't be in place yet. This will create a certain amount of some uncertainty for regulated facilities. We have had discussions with at least one state in Region 5, well, actually, and a regional authority in another state regarding this specific issue and how this transition period might be managed. One state had proposed something called an enforcement discretion memorandum, where essentially the state agency in that state would issue a memo advising affected sources to comply with the new subpart P requirements consistent with federal law, while the state went through the process of catching up and putting the revised regulations in place. That it remains to be seen, given some changes within the administrations in that state, whether that will bear out. But that has been discussed in at least one other state since the promulgation of the rule, and that may be an issue going forward, that trade organizations and sort of larger entities who have a significant stake and maybe their own government relations teams will want to consider. A few notes sort of regionally. Michigan and Florida are specifically called out in the preamble in the federal rulemaking. They had already adopted pharmaceuticals under their universal waste regulations, which is a separate streamlined procedure for RCRA. There won't be really a compliance issue in those states, because pharmaceuticals will continue to be treated as universal waste until such point as Subpart P is adopted by the states. Wisconsin and Illinois have not adopted state programs addressing hazardous waste pharmaceuticals. In some initial discussions with state representatives, they really haven't decided. They're considering enforcement discretion memoranda, but there really isn't much guidance. I should note that we didn't include Minnesota on this slide. Minnesota has a somewhat different RCRA program by state statute. It has a fifth characteristic, the lethality characteristic for hazardous waste. And Minnesota has had its own hazardous waste pharmaceuticals disposal policy since about 2011. So Minnesota will probably continue to just proceed under its existing regulations until Subpart P is adopted. And with that, I will hand the microphone back to Sarah to discuss specifics related to California.
Thanks, Pete. I'm going to just talk a little bit about California and some considerations in that state with respect to the revised rule here that we've been talking about. So first of all, just as a point, I know that this was mentioned on another slide, but here, just to again draw it out, there's a difference between hazardous waste pharmaceuticals and medical waste. And in California, it's relevant to note that DTSC, the Department of Toxic Substances and Control, is going to be responsible with respect to the hazardous waste pharmaceuticals under both the State Act and then under RCRA, whereas the California Department of Public Health is responsible for managing medical waste under the Medical Waste Management Act. And that act does include a number of pharmaceuticals. So to the extent that a hazardous waste pharmaceutical may not be caught up within this rule and subject to DTSC's jurisdiction, it may be that CDPH has jurisdiction. The other thing to consider is just with respect to reverse distribution. California has long been very critical of the likelihood of reverse distribution being functionally plausible, I guess is maybe a way to put it. And in particular, they have a history of enforcement. Excuse me. Between 2009 and 2015, they targeted a number of retail chains with pharmaceutical operations related to, in particular, reverse distribution concerns. And in addition, they made a number of strong comments in the draft rule about these concerns. So we think that they're going to be pleased with some of these changes, and we anticipate that they will that will align with the state's goals more so going forward. Also, with respect to the prohibitions on sewering, wanted to make a couple of comments. First, I just want to note that there was a question about prohibitions on sewering. And just to clarify that, the prohibition on sewering under the revised regulations prohibits the disposal of any hazardous waste pharmaceutical in the sewer. So it's specific to hazardous waste pharmaceuticals that are covered by the rule. I wanted to note here that lindane has already been banned by the state of California from disposal in sewers. And also, California has a number of counties that already have programs in place, either bans on certain disposal practices or programs that are in place to help facilities otherwise dispose of these types of hazardous waste pharmaceuticals. And so, we anticipate that there may be structures already in place to make this a more efficient transition. And then finally, something that is of interest in California is that DTSC has long had a different and more stringent interpretation of containers. So where this comes into play is with respect to certain hazardous waste pharmaceuticals, so whether they're listed or characteristically hazardous. If you have an empty container, and a container is a very broadly defined term. It can be, oftentimes in the environmental context, we think of a container as something like a 55-gallon drum, but in fact, a container can be as small as a vial or a test tube. So the way that EPA approaches containers is that so long as they are what is considered to be quote-unquote RCRA empty, which means that they have been properly cleaned and managed, then those containers do not require any special disposal. If to the extent that there are residues left in those containers, EPA's perspective is that the residues are hazardous waste materials that need to be properly managed. California takes a different perspective, and their perspective with respect to containers and what is relevant here is that if a container has a residue in it, then the entire container is considered by the state of California to be hazardous waste. And where this can be a significant issue is with respect to the tonnage and fee calculations associated with what is a hazardous waste and what's being disposed of. So that is something that that California had commented on and has policy letters on, and we anticipate will continue going forward. And with that, I will turn it over to Laura, who's going to talk a little bit about Texas and what we see there.
Great. Thank you, Sarah. And I'll be brief to give you an overview of where we think we are in Texas right now with respect to this rule. Texas generally mirrors the federal program for pharmaceuticals. TCEQ has a plan right now for how they're going to adopt Subpart P, but as they have a plan, it's an unclear plan. There are currently pending within the agency 2 rulemaking packages. The first in the queue, I understand, is a package of miscellaneous RCRA fixes, basically a hodgepodge of tweaks that they need to make to the RCRA rule to be compliant with the federal program or what have you, that are tentatively scheduled for proposal in the fall of 2019 this year, and then estimated adoption in June of 2021. That rulemaking package may include Subpart P, these requirements. However, there is some concern within the agency because Subpart P relies on certain RCRA terms and provisions that are expected to be amended in the miscellaneous package. So it may be that Subpart P must wait to go in the second package to piggyback off of rule changes in the first package. In any event, all states have 3 years in which to adopt the final new rule for Subpart P. Foley, we are currently in discussions with TCEQ on what to do about this compliance gap. We're talking with clients and TCEQ concerning potential industry guidance to address this and whether there's authority for that, possible enforcement discretion, which would be, of course, come from the Office of Compliance and Enforcement, or possibly other compliance strategies, whether it's orders, waivers, variations. We are exploring that with the agency and hoping to find a good, reasonable solution that the agency and industry can live with. And with that, I'll turn it back over to Pete for some prep talk.
Okay. Thank you, Laura. We're almost at the hour, so sort of final thoughts, how best to prepare. Key point, just most pharmacies have, or many pharmacies already have some type, and healthcare facilities have some kind of program to address compliance with RCRA, but not all healthcare facilities do. Most long-term care facilities have been exempted from the program, And so some may be caught unaware. As a matter, sort of key point on preparing, as a matter of tactics, starting with fundamentals, who owns compliance? Taking a set of regulations and translating them into a set of internal procedures is sort of its own art, and coming up with protocols to handle it. But who handles and sorts waste materials? Is it done automatically? Is staff trained to recognize pharmaceuticals and recognize the difference between something that's potentially creditable versus a pharmaceutical that clearly is not? Reverse distributors have lots of funny stories about things that get thrown into boxes shipped to their facilities. But does the staff know what can and can't be shipped? What's reverse logistics? What can go to a reverse distributor? We recommend audits, auditing compliance, sometimes with a third-party auditor. And in some states, and Laura can explain, and I have worked on both in Texas under their audit disclosure program, there is an audit disclosure immunity program. So auditing against the standard and resolving it sort of preemptively is a good way to find all the deficiencies and fix them. In the longer term, there will need to be, and many of these requirements can be addressed with good IT systems, and there are vendors who are developing them right now, to implement record keeping, to flag whether or not there has been an acknowledgement of a shipment to a reverse distributor, to identify, maintain contracts with disposal facilities for non-creditable hazardous waste pharmaceuticals, and to ensure that a reverse distributor that a facility is shipping materials to are in fact qualified. And finally, the overall plan for compliance. Many companies already have these processes or have a piece of these processes, but compliance with this rulemaking really can be managed, we think, with certain IT and will be streamlined. Getting from August 22nd to the date at which states have programs and entities can audit themselves and find themselves in compliance, that's where the work will be in the next 1 to 3 years. And with that, I think I'll turn it over to Jason.
Good afternoon, everyone. I hope you enjoyed today's presentation. I will be reading the code out shortly. I will give you about 30 seconds to a minute to complete the code, and I will repeat it a few times. The code is W as in water, 3, B as in book, K as in camp with a K, F as in fine. That is W, 3, B, K, F. And one last time, W, 3, B, K, F. I'll give you all a few minutes to submit before I move to the next slide.
Jason, could you just read it one more time, please, before advancing?
Absolutely. The code is W as in water, 3 as in the number 3, B as in book, K as in Kemp, and F as in fine. And with that, I will lead it over to Laura, Sarah, and Pete. Thank you all for joining today's webinar. I truly hope you enjoyed it. As a reminder, CLE will be provided within 8 weeks. And as an additional reminder, a recording of this webinar as well as the presentation materials will be sent out in the upcoming days. Thank you all.
Thanks, Jason. This is Sarah Slack, and we're a little bit past the hour, and I don't see that we have any questions. So if you have any follow-up questions, please feel free to email either myself, Laura, or Pete directly. We're happy to follow up with folks at a later time. Thank you all for participating today, and goodbye.